And it says that if you violate human rights, you are liable. I think we all agree. Then it says that if an alleged criminal has his rights violated, then he should not be tried. That's the summary of this case, of this law. So it says that in specific terms that if it appears to a judge or a magistrate presiding over a trial, it is brought to the attention of a competent court, or the court makes a finding that any accused person's non-derogable rights are right to a fair hearing, the right to be protected against torture, the right to be against slavery. Those are the non-derogable rights. Then upon the judge or the magistrate presiding over the trial shall declare a nullity and acquit the accused. That's section 11.2. That's the law. So it's saying if the court finds that this person in the process of investigation was tortured, or he was treated inhumanely, he was degraded, he was arrested in a degrading manner, that prosecution is null and void. Ladies and gentlemen, I hold the view that that provision is unconstitutional. That's my view. And the reason I hold the view, that view, is because one, the Constitution demands of the state that anyone who commits an offense must be prosecuted, must be brought to court. Now, let me give an example. A person murders someone in the village, and in the process of being arrested, he complains that his human rights have been violated. He goes to court and tells the judge that my human rights were violated. I was actually beaten, and this is what happened, so I was tortured. So the court indeed finds that this person was tortured. Let's assume that the court actually finds this person was tortured. Then the court says, you are acquitted of murder because you were tortured. That's unconstitutional, absolutely unconstitutional. Because acquittal must arise from trial. Acquittal must arise from a judge looking at the facts of the case and finding that you have not proved that case beyond reasonable doubt. Now, to find that an offense was committed against the accused after the accused committed an offense and therefore they are acquitted, I think that is a violation of the Constitution. But then again, doesn't the Constitution protect the accused as well as the rights of the victim? So if you acquitted the accused, what do you do with the rights of the victim? What do you do about the rights of the complainant? So there is a need for the courts to balance the pursuit of justice from both sides. You balance them by ensuring that the rights of the victim and the right of the accused have both been taken care of. So that brings me to the fact that the courts must exercise judicial discretion. Of course, I don't agree that a person should be put on trial when he's hurting from wounds and etc. But like you said, Honorable Justice Elubu, omusango teguvunda. So you go, heal, then stand trial. Yeah, you are tortured, go, get treated, then answer the charges against you. But also, the person who committed the offense that is alleged also has a right to be tried, give his defense in a criminal prosecution, and then find them guilty or otherwise. Try the person who violated who violated the right. Also try the person who committed the offense. It is in order to ensure that these violations do not compromise the justice of the victim, there must be transparency and due process. Now, colleagues who have come across this law, what happens is that you go to court, you have a person under charge, then the court is told, my rights were violated, then the court says, let's stop the prosecution of this charge, then the court, sitting as a civil court, the court sitting as a civil court stops a criminal prosecution. That line should never be crossed. Criminal law requires conviction beyond reasonable doubt. Civil requires proof on the balance of probabilities. How can a civil court make a finding that there was torture and on the basis of that call for an acquittal? It's a total contradiction, and this we must deal with. I also agree that arrest should be based on reasonable cause, reasonable suspicion. But let's not live in a utopian world. Let's not live in a utopian world. I was reading yesterday, and one of my colleagues had an argument that if the police enters a place with an arrest warrant to arrest me, and he finds in my house a cache of guns, but it doesn't have an arrest warrant, what do? So some very good genius told me that the police should go back, get a search warrant, then come back and get the guns. This is utopian. It's a joke. You have found the guns. I wrote back to the IGP and said, no, sir, please, when you go to arrest someone and you find evidence of a commission of another offense, get those things also. Don't come back and tell us I need a search warrant so I can go back and, while the criminal is there waiting for you, so that you come back with an arrest warrant. So we need to read the laws within the realm of reality. These laws are not there. They are there to protect both the victim and also the accused. But you must remember that criminal law is public law. And like Justice Elubu said, you must distinguish between public law and individual law. So, arrest based on reasonable suspicion. But who determines that reasonable suspicion? Is it the public? Is it the arresting officer? Is it the judge at the time you get to the court? It must be the arresting officer. The arresting officer is the one who must be reasonably convinced that there is a crime that is about to be committed or that has been committed, and then you arrest. But you can actually arrest before you complete the investigation. If in your view, the arrest will stop the commission of a further crime. So all these things must be done in the realm of that investigation, because when the police is dealing with criminals, it's not dealing with very reasonable people. But by no standards are they to be considered stupid. They may be unreasonable, but they are very intelligent people. It takes more work to commit a crime than to avoid committing the crime. Present a person before the court within 48 hours. We have read it to mean that I must present this person and charge them within 48 hours. No. That's not the view I hold. And I think it is about time we go to the courts to tell us what it means. I have arrested someone on the reasonable suspicion that he is going or has committed an offense. I have the murder weapon. Like Justice Abodo was saying, I haven't found the dead body, but I have found blood everywhere. I have checked DNA is there, but I'm trying to figure out whose DNA it is. DNA doesn't happen in 6 hours. DNA happens in more than 48 hours. It could take even longer. Now, we have our capacity here, but before we didn't even have the capacity. But this constitution has been here since 1995. So the rule in 23(4) is saying, bring the person before the court within 48 hours. You don't have to charge. You go to the judge, you say, I have person A in my custody. I believe, yes, I believe he has committed an offense. I have this much evidence, but I have 3 or 4 areas that I must check. I am asking you, my Lord, don't release this person from our custody. Allow us to detain them longer. The purpose of that law was for you to account to the court for purposes of habeas corpus, to make sure that once you present him before the court, then that person is under the custody of the court. In fact, the court may not even agree with you. The court may say, from what I am seeing, there is no reasonable suspicion, you must release them. That is up to the court. But we must be careful to read these things to say, 48 hours, they've reported an offense, I've arrested the person, I must do charge sheets. Okay, we are very efficient as government, but I don't think the law expected us to think, investigate, write, and finish. The ideal situation is the offense is reported, you investigate it, then you arrest. What if it is a terror threat? What if the police has reasonable suspicion this person is about to blow up police headquarters? But if he arrests him in 48 hours, I'm not ready to charge him because others are still at large. So what he does, because the Constitution says you must charge, if you read it that way, the police must release. Police releases and he blows up the building. We will hold you police accountable. Because you had him, you could have brought him to the court and then tell the court what it is that makes you believe. This Constitution was written by people who are clear in their mind. If they wanted to say, be presented before the court and charged, they could have said so. But they said, be presented before the court. But that is a matter we are going to deal with, because I am sure it is going to become an issue, and we shall come to the court and discuss with the court why we think. And in other jurisdictions, it has even been made clearer. They have allowed you, they've written laws and said, bring them, and then you can have the detention extended. And therefore, the trial is a nullity. Medical examination. A person is said to have been tortured. Police, you must now up your game. Because those of us who defend these cases need to be armed with sufficient material to defend the cases. I do not think you will find the conversation with me very pleasurable if they show me a picture of a person in a cast with a broken leg, and then you're telling me he wasn't tortured, he came that way. That when I arrested him, his leg was broken, he had 10 wounds, but you're telling me after he has complained to the court. Why don't you do the examination when you are arresting this person? Why don't you do the examination, have a good record of under what... It is not likely that a notorious gangster is going to come to police without a wound. It's not likely. Because if this person is notorious and has been carrying out these notorious raids, he's jumping over fences, going through barbed wire, breaking all into cars, he's going to have some wounds. But if you wait for him to complain, then you bring us a problem, and you bring the courts a problem. Now, we are struggling all the time with these cases where we have to go to the court and apply for substitution. You have brought this officer. What this officer did, in our view, was done in the course of his employment. So as the state, we accept that we will be vicariously liable if this person, if what he did was wrong. But the personal liability should be for the personal acts of the police officer. For example, if the person is in detention already and the police officer beats this person, that's different. That cannot be in the course of his employment. What was he doing? But a police officer is carrying out an arrest, and in the process of the arrest, they enter into a fight because he's carrying out an arrest. Then you say the police officer is personally liable. So we need to clarify that in the course of his employment. And we have many decided cases on that, but it's becoming a thing. And my worry with that is that it now says, the police officer says, why should I even bother getting involved in this? So what are we doing? We're going to encourage crime. Because now the police officer is saying, well, I'll be held personally liable. So he says, hello, Sumama. The man runs, says, if I chase this man, I'll be personally liable. Because if he chases him and he falls, I'll be personally liable. Come back, come back. We can't operate in that kind of setting.